recording. So this session is right in the middle of COVID-19. We're all in lockdown, which it doesn't really worry me to any great extent. It's actually nice to get off the road for a little while and start to really get busy. We're getting a lot of support questions around SMSFs, etc. I've got lots of stuff to show you. We're going to cover the Commissioner's guidelines of COVID-19. I did do a session yesterday on it. I'm going to show you our newly released rental reduction agreement. I'm going to go into licensing for accountants. I found an awesome guideline from the tax office, not from the tax office, from ASIC, that really gives you carte blanche to advise on anything to do with a self-managed super fund, even if a client comes to you and says, I'd like a self-managed super fund. You can lay open those arms, my friend, and say, absolutely, we are there to help you. So we're going to go through all of those ones. You can advise on contributions. If you're a tax agent, you can even go further than that. So it's one of those questions that really, I suppose, no one's ever focused in on. And rather than myself or a whole lot of lawyers pontificating, which they tend to do, I want to come down and let's have a look at what ASIC says on that one. Then we're going to have a look at the wills and the uniform legal profession laws, which have been adopted in New South Wales and Victoria, that basically provide that if you are simply doing a data capture or a transfer from a client's wishes, that in effect you're not providing legal services. The same way, if you have a look at it, a lawyer can't call themselves a financial planner or a real estate agent. There was a case in 2012 where a lawyer was charged with a breach of the Real Estate Act because they went beyond merely drafting documents, which is all essentially lawyers can basically do. And when we draft, we're talking about drafting from scratch, not from templates. That they extended there and they breached the Real Estate Act. And the article I actually looked at also said that a specific, it looks as though that law would also apply to that looks like that law would also apply the Financial Services Act. So lawyers can do what they normally do in legal practice, but they can't tell anyone to set up a self-managed superannuation fund. They can't advise on pensions, BDBNs, etc., so on and so forth. So it's funny how the legal precedent is actually the other way. But we're going to have a look at all that and a lot more. So I'm going to also deep dive into a couple of the LightYear docs, rental reduction. I want to go into wills as well, just to show you with accountants how we've protected you in terms of that data capture. So I've done a lot of work with my friend Tim Munro on that. So thank you very much, Tim, for that. And of course, my off-sider, Tony Anoulis, who's our lawyer at Abbott-Family, and you can see a little logo up there. But anyway, things are moving so fast at the moment. Look, I feel sorry for accountants. You must be getting smashed on what you can or what you can't get, and there seems to be limits on few and far between, whereas LightYear Docs is a startup, and it's very hard to find out whether we get or our staff get the $1,500 per fortnight. But Ashley from our office did a bit of digging around, and for startups, even if you weren't around 12 months ago, you can get it if you can show a drop in your revenue, which might be a little bit hard for us. But anyway, we'll have a look at that later on. But accountants, lawyers and planners, from my perspective, is we need to help clients overcome hurdles, find strategies, help them stay sane, and definitely don't put roadblocks in their way with some ridiculous legal concepts. I'm going to show you the tax office basically has come out and said, in essence, that we can put in place a rental reduction, even a rent-free period for COVID-19, and he won't take any compliance action to 30 June 2021. But then you go and listen to all the lawyers pontificating and saying, well, it could be a gnarly issue, it could be that, or it could be something else. But it doesn't matter because the Commission is not going to take compliance action against it. So while we've got that compliance holiday, particularly around rental reductions, even if it flows through an LRBA, 1322C trust, etc., look, then we take it. And I would duly expect that the next one we're going to see is not only rental reduction, but also loan repayment reductions. So we'll come and have a look at that. And the other one is we don't increase prices at the moment. I saw now Infinity, my old firm, actually increased their prices. I mean, it's not now Infinity anymore, it's Class. And Class obviously have worked out that some of the ridiculous pricing that now Infinity was charging was not amenable. So they're starting to uptick, and I would dare expect that once the 12-month contracts are over, you're going to see quite a significant increase in prices. But look, it doesn't matter. It's just silly putting in increased prices at the moment. So we need fast, affordable, executable strategies for our clients. We're getting requests day in, day out to build new documents for clients, whether it's a will that the accountant and planner can do for the client quickly, or for the latest is a rental reduction agreement. So I've got one of our advisors to thank for that. They said, look, have you got this? Because we need to put it in place. Otherwise, do we just do a minute? Well, the problem is you can't do a minute between the landlord and also the tenant. At the end of the day, you need to have a properly drafted legal document. Otherwise, once all this is over, the landlord can come back and sting you for the increases, and potentially not directly. They may well sting the guarantor or sting you through your security deposit. So you've got to have protection the whole way down the track. So we're going to have a look at that one. As I said, reduced loan repayments are on the cards, but if they come out, then I can tell you what, we'll be there and we'll deliver within 24 hours, and that's our job, is to get it up, get it ready, test it out, and deliver it for 24 hours. So it's a win-win, win for the client, win for yourselves, and also win for us. We want to move, and we want to move quickly, so that's pretty important to us. So let's have a look. I just did a bit of a session on this yesterday for an hour, but I'm just going to take you through for 5 minutes if you don't mind, because this is absolutely important. There's 100,000 SMSFs with business real property leased to related parties. They should have been on a rental reduction plan from the 1st of February. That's when all this stuff happened. You could probably even dial it back to 1st of January when it was starting to bubble up, but certainly from 1st of February, no later than 1st of March, we need to have in place a rental reduction agreement. I'm going to take us to the tax office very shortly, but the Commission has basically given us a compliance holiday until 30 June 2020 we'll have a look at. Unfortunately, investment strategies are not excluded from that compliance holiday. So if there is an adjustment, we need to do that. I've just we're releasing a new investment strategy today, which covers members' retirement objectives, and also more detailed in relation to insurances. So if you've previously done investment strategy with us, that's okay, or you can go and relaunch it as well. But it's really up to date. We've worked with the auditing profession, and now, look, I'm super happy where we are with the investment strategies, but there's no compliance holiday, unfortunately, for the Commission around investment strategies. But there is in relation to waiver of rents and rental reductions. So I've built this one, but it's not, as you'll see when we build it, it's not just for related parties between SMSFs and non-SMSFs. It's actually can be used for any rental reduction agreement. So a lot of your clients are hurting, and particularly landlords have got clients or businesses or even rental residential leases where the clients effectively, look, they may not pay, or they can virtually say, well, we're not paying, and you can't be evicted. So it's probably best for the landlords to be on the front foot, get a reduction in rent for a period of time. Hopefully at the back end, if you're an accountant, you've got that reduction in mortgage payments, or we've got that free period from some of the banks. And then from there, that we've got something on foot, knowing that once that period's over, and maybe just do a 3 or 6 month period, and once that's over, then the existing lease goes back on foot. It's far better to do it legally, and that's basically where you guys stand at this present point in time. So it's not only just between SMSFs, but it's basically between any party. So if you think of how many leases are in Australia at the moment, there's a great opportunity there. So every cloud has its silver lining. So it's best to get on the front foot. So let's go in. But the key one is we don't only look at rental reduction and waiver. We also have to look at outgoings if it's a commercial lease. If it's a commercial lease, also change of permitted use. I know, for example, there's been a number of restaurants who effectively have been opening their doors and selling food wholesale and farmers markets. That would be a breach of a commercial lease because usually the permitted use is as a restaurant, not as a wholesale food market. So this document actually opens up that permitted use and also in the future may sublet so that we might have 3 or 4 people in that one premises. So it needs to take that into account. And as I said, for a guarantor, if there's a guarantor in there, you do a rental reduction, but that's not much good if you find that later on that the landlord is going to ping the guarantor for the difference between the lease payment in the lease agreement versus what the reduced rent is going to be. And the same, obviously, security deposit. If they can go and then ping your security deposit, it doesn't make sense. So again, we've covered all the bases there and worked pretty hard for 48 hours to get it right. So let's just jump out of there. Let's go and have a look at what the Commissioner says here. I've got a few things that I want to go through, as I said. So this is the last will and testament. Let's go through here. So this is the Commissioner's COVID-19 frequently asked questions. So you see he's got a whole page. Just if you go ATO and COVID-19, it's going to pop up here. So there's some great stuff here. You've got the job seeker, support for business, individuals, employees. You've got COVID frequently asked questions, which then takes us to a page depending on which one we are. We're obviously in the self-managed superannuation funds. So we just pump ourselves down there. I think most of us know that superannuation minimum payment amounts have been changed. We changed our documentation a while back when it was first countenanced a couple of weeks ago, so that if you are going to go and do minimum payments for this year, it's probably not a bad idea to go on our site and set up your minimum payment under our site and set it for this year. So it's already taking into account the reduced, the 50% reduction. Now, temporary reducing rent. So question. My SMSF owns real property, wants to give my tenant, who is a related party, a reduction in rent because of the financial impacts of the COVID-19. Charging a related party a price that is less than market value is usually contravention. Given the impacts of COVID-19, will the ATO take action if I do this? So if we have a look at it, there's quite a few things there. There's obviously potentially a breach of Section 109 of the SIS Act, potentially sole purpose test breaches, maybe even in-house assets, probably not if it's business real property, but certainly gnarly income would apply. And that would also be the case if we end up with LRPAs and we reduce our payments. So the answer to this is like really a big one. Some landlords are giving their tenants a reduction in or waiver of rent because of the financial impacts of COVID-19. And we understand that you may wish to do so as well. Now, here's the money shot. Our compliance approach for the 2019, 2020, 2021 financial years is that we will not take action where an SMSF gives a tenant who is also a related party a temporary rent reduction during this period. So gnarly, off the table. Section 109, off the table. Sole purpose test, off the table. So not only is that help, but if you give advice around this, you guys are also going to be protected. So this is a compliance holiday around this, and this is the Commissioner's guide for us in terms of SMSFs. Actually, I'm just going to pop in here. See, carrying on a business in SMSF. Let's have a look at what the Commissioner says. I like this. Oh, there we go. Self-managed super funds are not prohibited from carrying on a business, but the business must be allowed under the trustee and operate for the sole purpose of providing retirement benefits for a member. So love that one. Commissioner's got some great stuff on his site. In-house asset restrictions, have a look at that. Super balance losses, investment strategies, but go through and have a look. Essentially, trustees must prepare and implement investment strategy for the fund and review them regularly. So it doesn't give any leeway around that. So investment strategy has to be on foot. So make sure you're using a LightYear Docs investment strategy. So let's bounce out of there and bingo, bango, bongo. Let's go to our product categories. Because of time, I'm going to rip through this pretty quickly. You'll see that the agreement is in our business and commercial agreements. First one up there is our rental reduction agreement. It's $99, but because I'm on unlimited, I can just start the document there as well. So if you're on pay as you go, you're ready to go. You can go and start pumping these out for $99. It's absolutely crucial. Please, I've seen a couple of people actually take the template, pull down the template, and then obviously use it for multiple clients. It's only $99. We're there not to rip off and gouge, but we're running a business like you, and that's a breach of copyright. So just watch out for that one. Anyway, we can start the document. Now, I've done a document before. I did this yesterday. So if you don't mind, I'll jump into that. So I'm going to go into my vault. And for those of you, so this is where all your documents sit. And you'll see the one I did yesterday, the rental reduction agreement for Smith. So I click on that and I'm relaunching that. So off we go. Now, what will pop up there is the document itself. So I've got rent reduction for Smith. I've put, for those of you who are on licensing or our unlimited platform, which is, we've got some pretty good pricing on that at the moment. It's AM001, which is for if you want to use the logo being Abbott-Family, or for those of you such as Belmore's and Madden's and all that, you've got your own logo. If you haven't got your logo, send it in to us. Use this support. Just simply put your name, your email. How can we help you? We like this logo uploaded. Put the logo, and then suddenly you're going to be given that there, and that'll be a white label for you. So we go down to the landlord. We can see here I put in the Smith Family Super Fund. Now, again, this is to be used for, it can be used for commercial, residential, and also rural property. So I've used an SMSF, but it could easily just be a company or an individual leasing a residential rental property to someone else. So it covers all of that. But I'm using the SMSF just to show you how we're getting that compliance holiday. Thank you very much, Commissioner of Taxation. So we've got a company, the corporate trustee, ACN. You've got the street address, which is put in there. 2+ directors. So we've got John and Sally both in there. Now, because it's a lease, we need to put in our contact details. So you put in the phone number, email address of the main person concerned, which obviously is going to direct the corporate trustee, and then put in the SMSF's ABN. We then go in up here and we have a look at the tenant. The tenant is going to be our family trust, but could be a company or an individual, doesn't really make any difference. So we've got the Smith Family Trust, again, a company, but now it's just Smith Proprietary Limited, new ACN, but the same street address. So that's probably going to be your registered office. But here, we've only got one director, being John Smith. Same thing, same telephone, email, but notice how we've got a different ABN. So that's not a bad position. Premise details, as I said, could be commercial, residential, rural, but we're going commercial, and that will then flow through the whole document. We put the address in there, unit number 4, 100 Brown Street. Is there a guarantor? Now I've got, because this is between related parties, I've got no. Does it have an agent? No. But if I've got yes, then when I come round to the agent, I put all the agent's details in there. And likewise, I can put in there, is there a guarantor? And you can see there's the guarantor details in there. So either one of those, particularly with a guarantor, you'll find there's an exemption for the landlord claiming above and beyond the reduced rent. Now we get to the money page. So this is the rent adjustment. The date the agreement's to commence. So started back at the 1st of February 2020. Look, let's face it. Hello, what are we looking here? What is that saying? It's saying 2019, 2020. So don't be super aggressive, but definitely take it back to at least February. Now, the date of the deed, just put in today's date or the date it's going to be executed. Date of the existing lease. Now, remember, this agreement fits on top of the existing lease. We can't void the existing lease, otherwise we've got problems. So put in your existing lease date. I've just got a weird question here. Roy, what are your thoughts on having a guarantor once a related party? Probably if we're doing market valuation, it'd say, okay, generally our commercial lease does put in a guarantor, so it's not a bad idea. But at this present point in time, if I was doing a new lease, I certainly wouldn't put a guarantor in there as well if it's a related party. Interestingly, on that one, Roy, sorry, with the LRBAs, remember we've got the related party loans. Now, this is obviously not a rent agreement. The Commissioner allows you to mortgage the property but doesn't require a guarantor. So it's probably not a bad side. You can actually go to TR 2006 or PCG 2016/5. If he doesn't want a guarantor for a rental repayment, then probably the same for a lease. So maybe use that one, Roy. How's rent to be paid quarterly? The amount of the reduced rent is $1,000, but let's say we actually taking it down. We're having really hard times. We're taking it down to $100. Does the rent include? No. So when will the agreement cease? So I've put in a few buttons there again. You know, when economic business conditions return, that's a bit flexible. And I'm trying to use at the same time the fact that the Commission is giving us this holiday. If I put in like 4 or 5 months, the last thing I want to do is I'm going to have to, if it's still crap in 4 or 5 months, I'm going to have to extend it further. So I can do I can choose here when economic business conditions return, when the Australian Tax Office compliance states rent should return to normal, or a time as agreed by the parties in the future, or I've just put 1st July 2021 in there. So now, if it's commercial, there's obviously going to be outgoings in relation to there. So from that perspective, we've got you can add additional uses. So for example, I might put in there to run a wholesale, oh God, sorry, I haven't got my my keyboard lined up. Sale food market. I can put in there other special conditions if I wanted to, but let's say that we've just gone through there, that's it. And then what we do is we finish off the agreement. So that's essentially here ready for you guys to use straight away. So again, I'll come down into a PDF. You can save answers. We're finding the best browser to use. Oops, sorry, let me go back. That's because I had it open quite a while. So let me just go back and see what happens there. I'll just relaunch. The best browser is Internet Explorer, and obviously you can see I'm using Chrome there. So let me just see what happens if I finish. Hopefully that will pop up. If not, I have got another example here for us. So there we go. As I said, sorry, it was because I was using Chrome. Use the latest. See down here, little Microsoft Edge. Use that's the best, but Grant's just a bit lazy today. So there you go, COVID-19 Commercial Property Rental Adjustment Agreement. So that's between the Family Super Fund and also the Family Trust. As I said, you can't do this by way of minute, otherwise you're going to blow yourself out. So key terms, landlord leases thing under the existing lease. As a consequence of the slowdown in the economy, as a consequence of the coronavirus and through no fault, the landlord hereby agrees to adjust the rent. The guarantor, if any, will be released of their obligations for this period in terms of rental amounts owing above the adjusted rental amounts. Then the date's made on the 1st of February. So we've got the parties, the tenant. Is there a guarantor? We said not applicable because we didn't talk that. It's the premises, the term of the rent actually goes to the 1st of July 2021. It's $100 per quarter. The rent must be paid quarterly. Go on and just have a look at all that. So I've actually adjusted the outgoing. So the reduction is 100%. So it's not going to pay. It's actually what is the reduction. And then I put in here further terms if it was a restaurant to run a wholesale food market. I won't go through this, but as you can see, it's a 16-page lease. It's what we use for our commercial lease. But what I've done is I've pulled it apart. So I've got here under the existing lease agreement, the tenant, if the tenant fails to pay rent or other payable under the lease, landlord may apply the security deposit, the amount payable under the bank guarantee. So for the period of this agreement, 4B, which is this one, only applies to the adjusted rent amount, not the rent shown in the lease agreement. Now, if you don't have that in, you're leaving the guarantor and security deposit opposed. This is particularly, where it's related parties is not a big thing, but certainly if you're going to use this for general parties. Anyway, that's there. It's up and running for $99. For those of you who've got unlimited access, I'd be getting on the blower or get one of your staff on the blower now and I'd certainly be something to I would be letting all my clients know now to put this in place in the next week so you can do the rent. Sal, good to see you on. Just to clarify, ATO will allow rent waiver, but not rent reduction, but not waiver. So if we have a look here, Sal, it's a good question, because when I have a look here, so if we have a look, this is a question. Some landlords are giving their tenants a reduction in or a waiver of rent. Now, a waiver of rent is a zero. So you're actually waiving the rent for that period. So that's a complete rental reduction for the period, such as like, well, in any promo, sometimes you have rent-free periods. So to see there, Sally, which is a really good question, that the waiver would carry. How much are most advisors charging for this doc grant? I would say there's, Gary, I know that you're an accountant. What you'll need to do is check out the cash flow of the SMSF, check out the cash flow of the business, work out what is affordable. Now, we've talked just about waiver or $100. Work out what is reasonably marketable for the current state and play, as if it was a true third party. So there's going to be a few, well, probably 2 or 3 hours work there for you. So I'd expect you'd be looking at, probably $750 or $950, maybe even a bit more than that. So that's essentially what I would do on. Okay, so Sally's in my ear, which is good. But read further on, not taking action for temporary rental. Okay, so Sally's saying there, some landlords, blah, 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 waiver rent. Our compliance for financial years is that we will not take action where an SMSF gives the tenant, who's also a related party, a temporary rent reduction. Okay, so that's, again, I mean, that's why Sally used to work for me, because she's a super smart person. Probably there, I would do a rent reduction rather than take it down to zero. So thanks for that, Sally. Definitely semantics, but it's worthwhile semantics during that period because you don't want the commission to bounce out. So don't do a zero, do $100 or $1,000 or so on and so forth to do that. So again, thank you for that, Sal. Well done on that. Now let's go in and have a look at the asset guidelines, which I am going to send to you from as part of this. So I'll send you this video. I'll also send you these asset guidelines. So I've marked them up for you just to show. So this was released in 2018, but certainly didn't get much exposure. So this information sheet, 2016, let me just blow it up so you can see it, because I know people such as yourself, Sally, have got pretty hardcore glasses. But anyway, let's have a look at that there. Oops, no, that's probably okay for you, but it's probably not okay for everyone else. So the information sheet is for accountants who provide services relating to self-managed superannuation funds. So the Corporations Act regulates people who provide financial services as certain types of services or activities related to financial product. Financial products include an interest in a self-managed super fund and many of the investments that are held by an SMSF. So an interest in a self-managed super fund is a member's interest in an SMSF, not a trustee. So I just want you to understand that one. Where we're advising a trustee on a particular issue, we're generally not going to be caught under licensing unless it's a specific investment. So the financial services typically provided by an accountant might include providing financial product advice or dealing in a financial product. Now, generally, you're going to need an AFS license. However, this is the big one. However, there are a number of exemptions from the requirement to be covered by an AFS license, including for accountants, and more importantly, we'll see later, tax agents providing services relating to SMSFs. Now, notice this is not a limited license. This is an exemption from an AFS completely. These exemptions apply to a variety of different activities and outlined in Table 1. We're going to get to that. They talk about the form exemption, but who cares about that? And then they look at the limited AFS licensing regime. So we won't look at that because, again, we want to have a look at the full exceptions. So an SMSF is permitted to borrow money in limited circumstances, subject to certain rules, for example, having limited recourse borrowing arrangements. Now, it's not a financial product, but they do say it may be a margin lending facility you may need to have an Australian credit license. But there's nowhere in here that actually says if you're advising on an LRBA and property that you need to be licensed at all. Just be careful of your Australian credit license. Okay, let's go and have a look at exemptions for certain SMSF services. You can have a look at all through this, but Grant's done the right thing and I've just marked it up. Now, see this? Exemptions that apply for SMSF services. So this is not a lawyer. It's not, someone from Cooper Grace Ward, D. Barry Butler or whatever. This is not even me saying it. I am just reading the words that are in front of you. So let's go through. Recommending that a person acquires or disposes of an interest in an SMSF is a financial product advice requires you to be covered. Okay, that's stating the fact. There's also financial product advice if you recommend that a person should not dispose of an interest in an SMSF, or that they should remain in their non-SMSF super fund, should not acquire an interest in an SMSF, because this is financial product advice about a person's existing interest in a super fund. However, there are types of advice and services you may provide without a license, and that's what we want to do. So the first one, and we're going to go into a bit more detail, and this is under the CIS regs, corporations regs. So these are still applying. Establishing, operating, structuring or valuing. Now, here's the deal. You may provide advice on establishing, operating, structuring or valuing an SMSF as long as you give the client the appropriate warnings. This includes advice provided for the sole purpose of and only to the extent reasonably necessary for ensuring compliance with superannuation legislation, or advice on the process of winding up or exiting an SMSF. Now, it does go into a bit more detail further, so I will have a look at that. Now, asset allocation investment strategy, which is the big one, you may provide a recommendation or statement of opinion on how your client should distribute their available funds amongst different categories of investments. So remember, the client here we're looking at is not the member. It is actually the trustee of the fund. And he's going way beyond, and I'm going to have a look further. He's actually saying you can talk about asset allocation and tell the client how they should spread their asset allocation to be, for example, a balanced fund. Probably, I wouldn't want to go and do that, but it shows you that doing a plain old investment strategy is pretty easy. Tax advice. You may provide tax advice on financial products such as an interest in an SMSF and underlying investments held by an SMSF, as long as you do not receive a benefit as a result of your client acquiring a financial product. For example, obviously you don't charge a financial product fee, or alternatively you don't get a commission, which I don't think is available. And you give your client the appropriate warnings, which we'll look at. So you can actually provide, so if someone says, look, I'd like to invest in, let me just see, I'd like to invest in a ESIC investment. So my super fund wants to invest in, like for example, I think LightYear Group, this is our last year of being an early stage investment company, so that anyone investing in us can get some tax relief per se. But what we can do from that perspective is we can tell the client around the 20% tax offset, non-capital gains tax, so on and so forth in relation to that. Now, this is a big one. If you're a registered tax abasset agent, you may provide advice as given in the ordinary course of activities of such an agent as reasonably regarded as a necessary part of those activities. Nikki Sheeran, reading investment strategy, just to be clear, does that mean as accountants we can advise investment ranges and benchmark? Nikki, I tell you what, I'm not going to say anything. I'm going to show you a little bit later exactly what ASIC says. And when we come down to licensing, it is ASIC that is the regulator. So what's gone on here is the bee's knees. It's not any of the other rubbish. This is what the real deal is. Okay, so let's go through and get into the nitty gritty. Establishing, operating, structuring, or valuing. You may provide advice on establishing, operating, structuring, and valuing SMSF without a license. So again, you can provide advice on the practical steps that need to be taken to establish a wind-up of fund, how to add new trustees and members, which is good, the different ways an SMSF could be structured, for example, accumulation, pensions, or how to process transfers or rollover of funds. Assist clients to complete paperwork to acquire securities. Help clients to add new members and trustees to the fund or exit the fund on divorce or death. So that seems to be pretty full. Arrange to wind up an SMSF. You may also provide other relevant factual information your client should know about establishing an SMSF, such as they've got to have financial. Now, you can, as I said, you can only rely on this exemption if the advice is provided to a trustee. Again, as I've said before, trustees are exempt. They're exempt under the Corporations Act. So when you're advising a trustee for investment strategies, etc., you're not caught under the Corporations Act. Now, it's only when you get down to member level that's important. So if, for example, they want to take contributions and set up the fund, then we have to look at that. So the advice must be given to the person in their capacity as a person who controls the assets owned by the SMSF and not their capacity as a beneficiary. Does that make sense? That, to me, that's the guts of this stuff. Now, we won't worry about that versus retail. Now, however, we recognise this is like the tax office COVID-19. This is their, look, we don't mind this. However, we recognise that advice given to a person about the establishment of an SMSF. So this is not the trustee. So we've already covered the trustee of how to set up, do an investment strategy, adding a new member, getting rid of a member, get a trustee, what's in the trustee, do a BDBN, set up pensions, etc. So we can advise on all that. However, recognise that advice given to a person about the establishment of SMSF may also carry an implicit recommendation to the person acquiring interest in the SMSF, obviously. So they go side by side because we can talk to the trustee or potential trustee, but at the same time, we're talking to them as a member. That's just the very nature of a self-managed super fund. Therefore, you are more likely to be able to rely on exemption when, now, here's the big deal. Let me go through. I'm going to take this off. I'm going to put it back on for you a little bit later on. So, whoops. Oh, okay. Let me just go through. Okay, I'll come back later. So, therefore, you are more likely to be able to rely on exemption when your client has already made a decision to establish the SMSF before seeking your assistance to take next steps. For example, you may recommend the best structure for an SMSF to suit your client's situation after made a decision to establish an SMSF. So one of the things I'm going to put up on our site is that if a client comes to you, that effectively there's going to be similar, I'm going to work out whether it's going to be an affidavit or a note. I'll have to have a chat with Tony about that, is that effectively they will be requiring, or they would have come to you and requested the establishment of SMSF. So if they've done that, then effectively you've got it from there, and then you can go through the process, the steps, the formats to actually set up that SMSF. Now, advice for ensuring compliance with superannuation legislation may also provide advice that's for the sole purpose and only to the extent reasonably necessary ensuring compliance with super legislation. So, modifying contribution levels due to changes in the super guarantee levy or complying with rules on investment restrictions. So, I'm running out of time, but I'll go through. If you provide advice about compliance with 52.2F, which is our investment strategy, the SIS Act, so this is the issue that we were looking at before, and I'll come back to you, Michael. If you can provide advice about compliance with 52.2F, the SIS Act, which places a duty on trustees to act fairly with dealing beneficiaries, or advice about compliance with Regulation 4.09, which talks about investment strategy, you must ensure that the advice is not about the acquisition or disposal by a super fund, including an SMSF, of specific financial products, which I think most of us do that. Like, we don't set up an investment strategy, say, okay, well, you're going to have a base of between 20 to 40% in equities, and what we suggest is you invest in BHP, Telstra, and all that. Now, if you go beyond that, then obviously that's financial product advice. But the 20 to 40%, absolutely. Does not include a recommendation person acquire or dispose of a super product. Does not include a recommendation about a person's existing holding in the superannuation product for the purpose of modifying investment strategy. So let's go down to asset allocation investment strategy, which is the issue we looked at before. Without an AFS license, you may not advise your client about their retirement investment strategy, including whether your client should increase or decrease their contribution to SMSF, what their overall investment strategy would be for their SMSF, or what contributions they should make to their SMSF relative to any other super fund. However, you may provide a recommendation or statement of opinion. So this can be written to your clients on broad asset allocation with their SMSF. That is, what proportion of funds should be allocated across one or more of the following categories: shares, debentures, deposit products, manage investments, and any other type of assets. Now, that is a pretty radical. So he's not only talking about you can do your investment strategy, but you can actually advise there. I'm going to say it again. However, you may provide a recommendation or statement of opinion to your clients on broad asset allocation within their SMSF. That's under Regulation 7.1.33A. Providing a recommendation or statement of opinion to clients on asset allocation with their SMSF is different from providing class of product advice, which requires a license. Okay, let's go down and see what other juicy ones we've got here. So if you've got a specific product, AFS license, particular class, but obviously if you do investment strategies, you're not. Now, tax advice. Providing tax advice is a core part of an accountant's practice. That's what I think we'll all agree with that. However, in the course of providing tax advice relating to SMSFs, you might also provide financial product advice. For example, this is the incidental. When you advise on the taxation implications of acquiring, holding, disposing of an interest in an SMSF or financial products such as setting up a pension or disposing of shares, this could be financial product advice because it might influence a decision about that product. Under 7.1.294, that's regulation, you may provide advice on taxation laws, taxation implications of financial products without being covered by an AFS license. This exemption allows you to provide financial product advice on your client's interest in an SMSF or financial product they hold through their SMSF, as long as this advice is merely incidental to the tax advice you are providing. However, here's the thing. You can't receive a benefit from the client acquiring financial products. That's important, so you can't get commission on that. The client's a retail client, and you say that you're not, so all we have to do is just do this letter. I'll probably put this up on the side as well. You're not licensed to provide financial product advice. Taxation is only one of the matters that must be considered, and they should consider taking advice from an AFS licensee. So you should actually be getting here. There's a little bit of difference, a deep, bifurcation between what you can do in the planning side of your business and also the accounting one. Now, I won't go through. I'm getting to the end. I have to get to the will bit. But tax agent and BAS services, if you're registered with the TPB as a tax agent or BAS agent, you do not need a license or to be represented. You're actually specifically exempted under Section 766B5C. So for the purpose of applying this exemption, a tax agency or BAS would generally involve advising on liabilities, obligation, entitlements as a client may have under tax law. So if we go up here, if we are advising on the taxation aspects of financial product, we remember we can't get remuneration and we also need to provide a statement to them. But if we're a BAS agent, we're providing tax on the liabilities, then effectively we don't need to that because we're exempt on that. Here, for example, a tax agent may provide advice on the tax implications of acquiring a financial product, such as an SMSF, but cannot advise on whether to actually acquire the financial product because advice on whether to acquire a financial product is not necessary to provide a competent tax agent service. So again, that's the end. They go through quite a few contributions. So under the exemption, a registered tax agent may provide on any tax implication contributions into an SMSF, such as a client's eligibility to make concessional, non-concessional in the tax treatment. For instance, a tax agent can use a client's total super balance to advise a client on eligibility for unused concessional contributions cap, the non-concessional. However, they cannot recommend the client make a particular level of contributions, although they can advise on the maximum level of contributions. So you can't say you can make like $23,190, but you can make any contributions tax deductible up to a cap of $25,000. So you can see there's a lot sitting in there. I won't go into, in fact, you can go through the tax implications of going for accumulation of pension. So all of these, again, have been prepared by ASIC. So I'll just go through this. So Michael Samuel, so as accountants, we can technically set up the fund, provide contribution advice, but not recommend how those monies invested. That's correct. So again, I'm going to send this to all of you with a recording of this session, and I'll keep it marked up. So have a really good look at this. I would suggest that you probably want to keep this very close to your box. So thought I'd read somewhere that these don't apply to those with a license. It depends. I'm not sure on that one, Sal, but if you could dig that out, that'd be great. But again, for accountants here, there is actually, if I do go back down, I'll come down here, Karen. There is a one down here. So you can refer clients to an AFS license. Okay, here you go. How the exemptions will apply if you're covered by an AFS license. If you're covered by an AFS license, including a limited AFS, you cannot rely on the exemption for the provision of advice to a retail client. This is because an AFS licensee or its representative cannot comply with this to provide a written statement. Okay, so that makes sense because you can't really say go and see this person. Therefore, any financial product advice that you provide to a trustee for superannuation, blah, 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 is not an exempt service. Shall be covered by the license. So if you're covered by an AFS license, including a limited, you can rely on the exemption to provide tax advice on financial products that are not covered by an authorisation in your license. Tax and BAS agents, if you're covered by an AFS license, also registered tax agent BAS, you can rely on the exemption to give advice. So most of you would probably fit in there. Look, I'll send this out. Have a really good look at it because this is your Bible on what accountants cannot do. Generally, my understanding, for example, Sal, that you probably have different companies that do the accounting side, and then you have different companies who holds a license. If that's the case, then have a look because then you actually bifurcate. And this is really get a line drawn, who does what and who does whatever. Now, with engagement letter, Karen, really good idea is should our engagement letters for SMSF specify that when we're corresponding with a client that's in their role as a trustee director? Absolutely. In fact, here's the first thing is for a lot of our staff, I'm telling you the truth here, Karen, a lot of the stuff at the moment, our clients are strapped for cash. And when they're strapped for cash, essentially what we need to do there is essentially they have money in their SMSFs, but not outside of that. So what we've got to be careful there is when we do our letter of advice, we do it to the trustee because then the trustee can pay us rather than doing it to the member per se. So load it all up in terms of how do you set it up, how do you bring a member on, so on and so forth. Licensing exemptions for accountants, we went through all that. The next one is completing a will from a data capture. Actually drafting a will from scratch. So if I brought a client in, drafted it completely from scratch, wrote in all the terms and conditions, and then set it on a solicitor and providing that, then that's a provision of a legal service. So that would be a breach of the Legal Professions Act. You can't hold yourself out as a solicitor, but that's the same thing. You're either an accountant, a financial planner, or a solicitor. So each of those are like the old branding. So you actually find the Corporations Act, that the term financial planner can also be only used by a person, financial planner. Solicitor, again, you've got to be admitted to the Law Council, etc. As I said before, there's lawyers are actually, very limited in what they can do under the Corporations Act. Tax agent, BAS agent is probably the best. So if you just do mere administration duties or data capture, then effectively it's not a legal service. So most of you have already seen our data captures for our wills. And what I want to do now is I just want to take you through. So this is one I did for our recent thing. I'm going to take you through the EPOA will automation. I just want to show you what we've got there just quickly. So we've added a couple of bells and whistles as we do. We get your feedback and we put it in very quickly. So for example, the stuff around the rental waiver, I'll make a note of that onto the system. So we're setting up the documents now. Notice here where this is an EPOA for Victoria and last will and testament versus will and testamentary trust. So are you an accountant? If you do know nothing, but are you an accountant or financial preparing this document from a client's data capture? Yes. The date of the accountant's data capture, you can put in that later, and the name of the accounting firm. So we'll actually put in financial planning firm as well. So I've got John's Accountants basically sitting in there. We've got our common parties. We've got our enduring power of attorney. I just want to show you something else that we've put in there. This is, I think this is awesome. So the replacement attorneys we've got in there, power of attorney. Now, what we've done is, this is quite radical. Most of you, if you're seeing enduring powers of attorney, they're pretty weak. And then we provide our enduring power of attorney straight off the relevant state government websites. So again, that's not the provision of legal service because you're simply getting the data and putting it in. But we have got a couple of different things there. So I've talked about this before, is you need to have a specifically enduring power of attorney that your principal, hopefully you can still hear me, the internet's better, that the principal or the attorney can act as a replacement trustee or replacement director, because your enduring power of attorney cannot guide the Corporations Act. So what we need to do is we need to put in place, yes, the enduring power of attorney applies. And then what we've got here also, I noticed that Tim said, well, what happens if you've got well, forget about super, but we've got a single director company, what happens there? Because your enduring power of attorney can't take over. You're going to have a general meeting and the shareholder, and if they're incapacitated, pretty well stuffed. Well, what we've got there is we've got a document you'll see where it can act as an alternate director, and we'll go through that a little bit later on. So there are a couple of new exclusions. We've got all our last will and testament stuff and all that. I won't go through that. I'll just go through our document ourselves. I think I've done this. So this is the last will and testament enduring power of attorney. Let's just go through here. Now, this is the first, because you've ticked the button that you are an accountant. It says the attached will and EPO is based on data capture form given to you by John's accountants. It uses a current legal precedent provided by a legal firm, Abbott-Family, to look after you in the following manner. 1, who and how a person you choose as your attorney will look after your personal, health, financial and superannuation affairs in the event that you are sick, quarantined in hospital, or unable to attend your affairs by being indisposed overseas or have lost your mental acuity. So that's your enduring power of attorney. Who and how your personal effects, assets, and property will be legally gifted and transferred upon your death. So this goes to the client. It is important that you read the following as it is of legal nature and extends beyond the data capture and administrative processing completed by John's accountants, but not solicitors who do not hold themselves out as such. So you can see we're following the cases. However, they are expert tax advisors. It's vital that any estate plan considers the tax impact of any gift or distribution, as taxation may be significant. So what documents are attached? Your enduring power of attorney, we go through the clauses, and essentially your will sign. Very important. Wills can be challenged in the Supreme Court by any eligible person, including children, grandchildren, ex-spouses, and others who feel they've been left out or not adequately provided for. This can delay the transfer of assets and with court costs eating your estate gifts. So if any of the following occurred or likely occur, please contact us immediately because we will need to provide you with a more protective, tailored will. So what we're doing is saying, look, these are lots. So do you have an ex? Okay. Okay, sorry. It looks as though, oh gosh. Sorry about that, guys. Where did I get up to? Can anyone let me know? So where was I up to? Because it looked as though the system just dropped off for a little while. So hopefully that you're there. Anyway, look, we've got here. You may need to go and get a testamentary trust issue. Very important. Okay, thanks for that, Gary. So obviously it's a little low. Okay, so very important. Thank you very much for that, Gary. What happens here is, because they can be challenged, if you're getting married in the near future, have an ex-spouse or separated, then all of these, you're probably going to do a will with a testamentary trust. So if I'm doing that one, and I think I'm here again, my internet's absolutely hopeless. So hopefully you guys are getting it. I think there's just too much going on at the moment, too many people working from home. So sorry about that. My internet's going down, but look, I'll just cover it off anyway and send you the recording if you can't hear it. So if we go through the final ones, we'll see, because we're getting towards the end. You guys can do the will and testamentary trust. Then we've got the next one, which is a general advice letter from Abbott-Family on executing your will and enduring power of attorney. So that becomes part of the kit. Talks about what you need to do. You can facilitate all that process because that's just admin. Make sure they sign the right pages, so on and so forth. And there's additional guidance notes, so on and so forth as well. So if we have a look at that, we're not in a bad position. So that's now part of the kit. Then we go down to our enduring power of attorney, and you'll see here the thing that is different is that, when we go back up, when we have a look here, that there's also a binding agreement. Okay, so there's a resolution by a company director to appoint an alternate director. So that's the one. So you can actually put a list you've got there, because I put in a bogan, etc. You will be getting all the notes and the slides, everything today. So I'll be sending that very shortly. So sorry about the interruption. But see in here, I put in bogan, and then you put in all the names of the companies for which you are a single director. and basically to ensure the continuity of the company. So what happens is if the enduring power of attorney applies, then the alternate director comes on for as long as that enduring power of attorney. So it gives a fine resolution. Anyway, it's getting towards the end. Again, sorry about the interruption. Obviously, we're going to have to get used to that, even though it's NBN. Everyone's working from home, and of course, it's school holidays and living in an area with lots of kids. They've probably got about 10 devices on at once and slows the pipes. But look, the main thing is from today is we've had a look at some pretty core issues. Get that rental reduction agreement in place for your clients straight away. It's $99 for those of you. I know a lot of you, Michael and Sally, etc. You're all on the unlimited, so just go out and do that. Work out your pricing. Get someone on the phone. Just say, look, we need to put this in place straight away. If it's SMSF, get the SMSF to pay for that and get it invoiced up front and then off and running and make the relevant adjustments. Again, just check your cash flow, so on and so forth. For the investment strategies, you're going to find there's some changes on that. I will send you through that PDF from ASIC. It's certainly enlightening from my perspective, and it'd be great to, obviously for more people, more practitioners to be aware of that. But go through the whole space, particularly if you've got two different businesses, one planning and one also accounting. But virtually accountants, you can do everything without having to do the bad stuff of advising on investments. Planners, I'll send that all through to you as well. And with the wills, just get that, use that data capture, which you can find on our system, the EPOA and LYD will data capture. And again, I might just spruce that up to include a little bit more on that advice. But all our LYD wills and EPOAs, if you've ticked it as the accountant, you're doing the data capture, then all of that information comes in. Anyway, that's enough from me. I will just check the things. So, yep, everything. So so sorry again about the thing, but I won't do any editing. I just want to get this up into you as soon as possible. Anyway, it's Grant Abbott signing off, and thank you very much for all attending in these busy times. We're there to look after our clients, certainly not rip them off. It's Grant Abbott signing off.